Any mentioning?
Well, Lordship, kindly to mention one matter, Lordship, for the undefended suit, Lordship.
Inclusion.
Inclusion. Undefended suit.
Yes, Mr. Sinha.
First item.
Item number 1, 2, 3.
Why not may be permitted to mention a matter? It's a probate matter. It's my application is non-contentious, my lord. Kindly be
For inclusion.
for inclusion.
Yes.
I permitted to mention one matter, my lord. My lord, CS 144 of 2018.
Is it
My
in
lord-
list today?
No, my lord. My lord had disposed of this matter on by an order of 27 March, my lord. My lord, we had applied to the registry for obtaining a certified copy along with a decree. My lord, due to some typographical error, my lord.
For correction.
Right, my lord. No, my lord, we just seek my lord's leave to obtain the decree from the registry, my lord. Certified copy.
Check it.
Item number 1, 2, 3.
My Lord, I appeal for the
Yes, is it done?
Yes, my Lord. We have
Second part has not been done.
Lord, the time has not expired. My Lord, my Lord,
Has
my
not been furnished as yet.
Lord, I hope my Lord would hold his horses. Lord, your Lordship was my Lord pleased to direct my Lord deposit my Lord of
What is last order?
my Lord Lordship takes my Lord your Lordship's order my Lord of 2nd April.
Just a minute. There is a note of the register original site.
Yes.
Just for you. 6th of
Milord, may I have your kind leave to mention, Mr. Banerjee is there, the Jagdamba matter 235, his idea also because it is listed has gone down in the list with 235. So this was the matter your Lordship was hearing on MSM.
One part has been deposited.
Yes, my Lord. The cash part my Lord has been deposited. For the bank guarantee, my Lord, we have no time my Lord till
take 10 more
Lord,
minutes.
for 4 weeks, my
My
Lord.
lord, both Mr. Banerjee and I are not in town today. Well, if your lordship will kindly keep it for reply, my lord.
I am in town. I'm not in town tomorrow.
Mr. Shah, you are audible in another court.
Mr. Shah will make his submission, then your Lordship will decide when to hear the only request is.
Now, problem is the
My lord.
note is there.
My Lord.
There should be some further direction to invest the amount.
Yes, your Lordship can issue
That
the
is not there.
My Lord, the other thing, my Lord, which I was saying, my Lord, we have time, my Lord. Your Lordship has given us time, my Lord, till 30th of April, my Lord, to furnish the bank guarantee. My Lord, the process is already on, my Lord. We have given it to the registrar, my Lord, to approve the format.
The order.
My Lord, it may just not take 3-4 days more, my Lord, if your Lordship could not extend it, my Lord, till 7th of May, my Lord, to furnish the bank guarantee. And my Lord, the another thing, my Lord, your Lordship has already, my Lord, defreezed the account. But my Lord, the bank, my Lord, is seeking for a clarification, my Lord, that my Lord, we want him, my Lord, to use, my Lord, that my Lord, the other fund, my Lord, the funds, my Lord, not required for the bank guarantee, but for payment of, my Lord, of the salary and statutory dues, my Lord, of our employees. So, my Lord, if your Lordship could just
Anger
clarify.
till 30th April.
Yes, my Lord, it is still.
Where it is made written.
Not 4 weeks. Your Lordship takes your Lordship's order, my Lord, of 2nd April. My Lord, last paragraph, my Lord, bank guarantee within 4 weeks, my Lord. 2nd April order.
Within 4 weeks
Yes,
from the
my
date.
So, not I'm only saying, not kindly not extend it till 7th of May, and not just clarify, and not your Lordship can direct the registrar not to reinvest the amount which has been deposited, and will not permit not us not to just clarify not because Lordship already defreezed it. Not kindly clarify that not we can use the other funds not required for the bank guarantee for the purpose not of salary and statutory payment of our clients.
Lord, the bank guarantee has not yet come. Your Lordships, kindly see the second paragraph.
I'm saying not the funds for that not will be set apart.
Yes, if that is.
Yes, I'm saying subject to bank guarantee funds being separate.
Bank guarantee
Yes,
funds
of
being
course.
kept apart,
Yes.
different can
Of
operate
course,
the
of course. I'm only saying that. Subject to not.
margin is not 110%. Kindly provide that in your Lordship's order.
My friend is not appearing for the bank, fellow. That is for the state to negotiate with the bank.
No, that is for them.
Lord, whatever, Lord, is.
The security
Yes. We will. এখানে আমাকে রেসপন্ডেন্ট করে দিয়েছিস আমাকে সুবিধা দুইজনকে Milord, me and Milord, my learned friends, advocate on record, might have also become respondent in the proceeding.
Not by us.
The 2nd April order, আমাদের respondent করে দিয়েছেন.
This was made clear in the earlier order.
Yes, your Lordship
The
already
freezing
made
is lifted.
Yes, my Lord, it is lifted. Yes. So, Lordship can just clarify, my Lord, that the bank guarantee amount will be set apart. Subject to that, it can be operated. I have no difficulty with that.
Once it is lifted, that's all. What do you need extra?
No, my Lord, because another line, the next line again says subject, my Lord, it says, my Lord, to this extent, the order dated stands modified. Now, my Lord, The bank, my
No,
lord, is
all right, I'm modifying that condition.
just
This
that,
much.
that. And my lord, one small correction, my lord. Your lordship takes 2nd April order, my lord.
Yes.
The cause title, my lord, it my lord gives my name and my lord friend's advocate on record name, my lord, as a respondent. My lord, kindly let that.
Oh, अच्छा.
My lord, after my lord Punanur paper mills, my lord, it's my name and Mr. Kakrania's name, my lord. That may be, my lord, corrected.
Give a slip.
Yes.
Corrections.
আমার নাম আর Mr. Kakrania's নাম cause title এসে গেছে।
Report of the learned registrar original site dated 21st April 2025. Be kept in record. Full stop. It is stated that on 9/4/2025, branch manager of Central Bank of India, Newmarket branch, Kolkata, deposited a sum of rupees 3,01,22,996.50 paisa with this registry by way of demand draft. Full stop.
Much better. Chicanely.
The amount has also been deposited in the P full stop L account of the register original site at RBI Kolkata by way of challan, mention in details in the note. Full stop. The learned register original site has sought further direction and instructions to invest the amount in any nationalized bank. Full stop. The learned register original site should invest the amount so deposited in any nationalized bank in appropriate scheme to earn interest.
Earning the highest rate of interest which is prevalent.
Appropriate, that is all. For fetching best interest rate. Full stop. Next para. In terms of
Reinvestment may be made within a immediately at the earliest.
yes, that direction there will be given. Next paragraph, the order dated 2nd April lifted
The attachment and freeze.
attachment and freezing of the bank account stated therein, subject to the condition that bank guarantee should be furnished within 4 weeks. For the sum mentioned therein. Full stop. The time frame will expire with the end of this month. Full stop. Mr. Sinha, the learned senior counsel, prays for extension of some time till 7th May. Enabling him to furnish bank guarantee. Enabling his client to furnish the bank guarantee. Full stop. Accordingly, order dated 2nd April 2025 is modified to the extent that bank guarantee shall be furnished on or before 7th May, 8th May, making it 8th May, that week, 8th May 2025. Let the matter appear in the list on 14th May.
Lordship, can you clarify, not that subject to not the amount required for furnishing the bank guarantee, not my clients will be free to operate the account. Not
There is no freezing, there is no attachment that was lifted.
very good. I shall communicate that. Very good. Very good. Clear, clarify. I'm grateful.
My lord, once the reinvestment is done by the learned registrar, my lord, if they
The learned registrar original side shall furnish a report on the returnable debt, comma, if possible, on reinvestment of the amount deducted herein.
Okay.
1, 2, and 3.
My lord.
There's an application of my client, lord, seeking addition of party in this app. At number 2 GA.
Last likha din. All these applications shall appear in the list on 8th May. No, sorry, I said 14th May. Exchange of affidavit is complete. Affidavit in reply
GA1 and additional party.
filed in IAGA com 1 of 24 be kept in record.
Opposing. Item number 4.
I appear for the defendant. This is that objection my learned friends had taken when I had tried to tender a document.
That case. Yes.
I have to give the reply.
Where-
My learned friend,
Where is Mr. Bosch?
My lord, Mr. Bose is on his way, my lord.
he has given his additional note. I am to deal with the cases in the additional note. If I may just take 5 minutes of
Let
my...
Mr. Bosch come.
Hmm?
Because he will say, I was not present, I can't reply.
No, I am giving a reply.
My
to
lord,
his
they have not yet given their additional written note, my lord.
So I have to make my submissions and I'll give
if
it.
they can give, my lord, because we have already filed and given them, my lord. So they can give us, and your lordship can take up the matter tomorrow, my lord.
Mr. Bose argued the matter that I
One
wasn't
thing,
there.
do one thing. Let this matter be no further issue. You hand over a copy of this notes of argument. Tomorrow I will hear it.
Yes,
Then I'll have to write my notes to give
No,
it.
no,
I've got
sorry.
my telegraphic
Okay,
notes.
okay.
Then I'll have to write it and give it. Then I'll come back next week then.
Next week or tomorrow?
But tomorrow the note I won't be able to. Because there are 9, he's relied on 9 new cases. Or totally, like before that 4 and now 5. I have to deal with those. I just wanted to explain the cases, how it's not applicable to my facts.
Your basic point was section 14 will apply.
4.
4 will apply.
What
Multiple
happened,
documents are there.
what happened, my lord? The conveyance refers to, this is made pursuant to a memorandum of understanding.
Yes.
So I confronted the witness. I said, have you disclosed this memorandum? I showed him. We showed him a copy. He said, yes, he signed this document also. Then he says, but we have not acted upon this memorandum. That was the witness's answer. Then when we tried to tender, he said, yes, I have signed, everyone signed. It was proved, the document. But at the time of tendering, an objection was taken that it is unstamped. It's not completely correct, my lord, that it is not unstamped, it was insufficiently stamped. Then, my lord, the objection was taken. Then your lordship said you will hear this objection. Then I've showed section 4, which says if there's a series of documents and the principal document is stamped, then the other document need not be stamped. So that is our case. Then Mr. Bose, after hearing that, he said, yes, I concede to that. But this document is not the same, a part of the same transaction. So my simple submission will be that is a question of fact which will be decided in the suit. Now, document B, that is the conveyance, refers to document A. So it's written in the document. So a parole evidence saying that no, document B is not based on document A doesn't lie. So prima facie, I have a good case that these are a series of the same transaction. So if the final document is admittedly fully stamped, therefore there's no question of the MOU. So this was the first objection he took. The second objection he took was the MOU refers to 2 floors, third floor and second floor. And this suit is only in respect of the third floor. The conveyance is concluded only in respect of third floor. So he says that in any event, document A is not fully stamped because it refers to 2 documents, which is the value of which is 22 crores, and stamp has been paid.
Yes, that was your argument.
So now I'll have to make that distinction, and I couldn't find any case exactly on that. So your lordship will have to decide that, except one case I found where, my lord, one document contained a will as well as a conveyance. And the Supreme Court held that as far as the will, such a document will be admissible in evidence as far as it concerns the will. Now, so my argument before my lord is document A refers to second floor, third floor. Document B is the conveyance for third floor. So as far as third floor document is concerned, the preceding document is admissible without stamp because it has been completed, the transaction. But now Mr. Bose says, but that document A refers to a second property which is not stamped. So your lordship, I am asking it to be severed.
So do
It's-
one
and
thing,
but- so
come
this
with the
is-
notes of argument,
I'll come.
because there is a fine finesse in the, Mr. Bose is here. Certain nuances are there.
This is the nuance, that is the main point, that if a document can be read that as far as third floor is concerned, there is nothing more for me to do to rely on the document. But I'll just put this rider before making all my submissions, that in the cases that Mr. Bose showed, those documents were the fundamental, the foundational documents. If I am asking for a decree on that document, but here I'm not asking for a decree. It just came up in cross-examination that the conveyance, which is the principal document, which has been exhibited, refers to a memorandum of understanding. That memorandum of understanding, the witness says that it was not acted upon. So I am entitled to show him that document under section 145 as to confront a witness because it is his document and he has signed it. So at that point, this objection was taken on the stamp, that is insufficiently stamped. The objection was taken that it was unstamped, but now Mr. Bose has said it's insufficiently stamped. So that is where it is at now. So our final submission will be that this can be decided only after all the evidence is over, because I haven't given evidence that whether or not the conveyance B was based on MOU A is a question of fact, which will have to be gone into. So, and I'll distinguish these cases that my learned friend has said, and those cases itself mentions the case where a document can be read as severable. Like as far as...
So come with the notes of argument and all the judgments.
Yes, I'll
He has already given his notes or argument based on 4. I have told over and over again, this memorandum and whatever he's relying on is not my document. It is part of the disclosures they made in their written
No,
statement.
Mr. Ghosh is trying to distinguish the two cases.
No, let them distinguish, but the fact remains those two documents cover the entire premises. The conveyance is relating to portion of third. I have mentioned this amply clear in my first notes.
Yes.
So he is trying
28 is good? 28 coming Monday? Monday I will finish it.
Yes.
Monday I will close it.
If he is relying on any new case, let them
on Tuesday.
Tuesday, all right, 29. But 29 I will close it.
Yes, if he just relies on any new cases, please tell me in 1 day in advance. Immediately I will give an answer. Because
I'm not relying on any new case. I'm relying on their cases to
making a distinctions.
Let them, of course, they are entitled to. I have given a supplemental where your lordship was about to pass judgment. Your lordship said I must refer it to that I furnish a particular.
It will not be a judgment. It will be simply an order.
As far as that,
my lord, we call it judgment because your lordship will apply your lordship's mind. Therefore,
Still an order, even in order. Even
that becomes it's
judicial mind, application of judicial mind. This much.
That is what I am saying.
As far as what fell from my lord, that whether this document should be sent to the collector to be assessed, whether or not it requires stamp or not, that I agree with what my learned friend has written in his written notes, that he says that is to be decided by the judicial authority, that is your lordship.
Yes.
The nature of the document can't be decided by the collector. So that is, it need not be sent.
So regarding that, the other aspect, we have already made our submissions. Lordship, I have made it in my
So
note.
two things have to be decided.
Yes.
First is whether it's a part of a series of documents.
Whether it is whether by paying duty in respect of a smaller portion, you can.
That is second issue.
That is the first.
First issue is whether this is part of a document. Yes. The final document or foundational document has properly been stamped or not.
Yes.
Second thing, whether the transaction relates to the same properties.
That's according to me, the first one comes. However,
that means whether it is properly stamped or not. That will be part of this issue.
That's the only, according to me, the only
That
issue.
is the part which
But
is
your
the
lordship
missing
raised a more fundamental issue. After side, why should your lordship decide? Why not send? To that we are addendum. I've given the supplementary note.
29.
Your lordship has kept it as part of, because otherwise.
Yes, we all decided on that. Why it is?
It has to be recorded.
No, no, it's there. I think. Ajke to record. हाँ, अरे, it's
Because it keeps changing and then again we want.
No, it is only part heard. That's why this application is here. The
That
suit
is
is
why
here. Once this will be decided, this will go from this court.
Yes, that's what your lordship, and your lordship should, because that's a problem.
Yes.
Item number 6. In the goods of Bharati Banerjee.
May it please.
What is J1?
Lord, I am appearing for the administrative, Lord. I am not.
It
is appearing.
One is my application. My lord, we had initially filed the application for removal of the executor. My lord, the executor filed an affidavit and said on account of old age, he is not willing to continue when your lordship had appointed Mr. Banerjee, my lord, to complete the outstandings under the will.
Have you filed any report?
No, my lord. The matter is appearing at my instance pursuant to my mentioning yesterday. I shall indicate, Lord. There were 2 duties that my lord had casted upon me. Duty number 1 was distribution of the gold kept in the lockers in 3 equal parts.
Probate was granted or LA was granted?
Yes. 3 equal parts to the beneficiaries of the estate. And duty number 2 was distribution of the securities held in the demat account also in 3 equal parts. Pursuant to that, not a meeting was fixed so that the bank manager could be approached with in the presence of all the beneficiaries. Lord, one of the beneficiaries who's possibly not present today, my lord. I'm sorry, who is appearing today, my lord, raised an objection with respect to distribution of the securities held in the demat account. It is their contention that SEBI guide that they are joint holders of this demat account, and that on account of them being joint holders, they are entitled to the first, their half of the entire securities held, and second, 1/3 of the remainder of the half.
Have you filed any report on this?
No, my lord.
File a report. Otherwise, if nothing is there in writing, how can I decide the issue?
Yes, my lord. Possibly I don't have the power with respect to the distribution.
Very good.
Portion.
You file
I
a
shall
report.
file a preliminary report on this point.
Yes.
Very
Mr.
good.
Banerjee, the learned administrator pendentity. You are executor.
Administrator of the estate. My lord.
Administrator
Of the estate.
of the estate. Please leave to file as a preliminary report. Full stop. Leave is granted. Preliminary report shall be filed on or before 15th May.
May I just indicate one thing? With respect to the distribution of the gold, there is no impediment. The parties
Come
are
with the
tied up.
report.
May I proceed with that, my lord?
Come with the
Very
report.
good.
My lord, I have one prayer, my lord. May the report be circulated, my lord, before the matter comes.
Unless this will come before this court, it will not be circulated. Let it come before this court, then.
Extremely obliged.
Grateful, my lord.
Item 7.
My lord, in item number 7, I have been led by my lord, by a senior, my lord. He is on his leg before court number 37, my lord. I am paying for a short passover, my lord.
8. Item number 8.
May it please, my lord.
Hmm.
When I appear
What
for
is
the
J1?
plaintiff, the application is for injunction. My lord, it's an interesting matter. My lord, the plaintiff is a club in the Maidan. It's a football team. They have a football club.
May I file the affidavit in opposition?
Yes.
Opposition. I want the reply file. Where is it? We have filed our reply.
Exchange of affidavit is complete then.
It's complete.
Have you filed reply?
Yes, we have filed. I don't know if the copy is there. Copy to us, reply. Hmm? Yeah, we've given the reply. Now, only one thing before I begin, and we are really challenging the method of election that has been followed in this by the Football Association, Indian Football Association, and we had challenged a particular notice asking for a meeting. Now, as soon as that, before the notice was sent, we made our representation that the election is not, everyone is not getting a chance to cast their votes because of the system that is there. I'll explain that later. Thereafter, we filed this GA to stop that meeting. But Justice Rao said there was only 1 day left for the meeting, etc. So it said that the meeting, the result, the outcome of the meeting will abide by the result of this application. So at that point, the matter was not heard. After that, there were affidavits. Now this is coming. But even then, my lord, a long time has passed. There are some subsequent facts that I need to bring on record. They are all matters of record. As in, we have taken this order 1-8, rule 8 at publication. That has to be brought on record. And my lord, some other few subsequent facts that have happened.
So you need amendment.
Not amendment. These are subsequent facts to bring to your lordship's
Supplementary
notice,
affidavit.
because Justice Rao's order says that all further appointments also will be subject to the outcome of this application. So if there have been some further or not, they haven't said in their opposition, but my instructions are there have been further appointments, and I need to bring that on record.
Supplementary affidavit. Mr. Ghosh, the learned senior counsel.
Sorry, my lord, I subject to my lord what your lordship decides, my lord. I think, my lord, the proper course would possibly be, my lord, that they withdraw this application and file a
Or amendment.
fresh application.
Then there be affidavit. No, should be no so hyper technicalities.
No. So it has to be.
So why should I withdraw this? I've got an order. I'm enjoying an interim order.
6 for Mr. Ghosh, the learned senior counsel, appearing for the plaintiff petitioner. Crave leave to file supplementary affidavit in order to bring to the notice of this court subsequent events. Full stop. Leave is granted. The same shall be filed on or before the returnable date. Let the matter appear, let the suit along with the application appear in the list on 15th May is okay?
Yes.
Anyway.
Oh, আরেকটা কথা লিখে দিন, affidavit in opposition as well as affidavit in reply be kept in record.
Item number 9 and 10.
May it please your lordship, my lord, 9 may be taken up separately, 10 may be taken up separately, because in 10, this is an assigned matter. I'm praying for extension of the interim order passed in 10.
So far as 9 is concerned, 2 applications are pending. GA1 of 24 in 9, GA1 of 25 in 10.
GA1, yes, my lord. May I just clarify?
You are
number 9.
You are plaintiff or
I am for the plaintiff.
In which matter? Both.
In both the matters.
Yes.
Item number 9, lordship, we had filed a...
You are here.
We had filed a
My lord, I am in number 10. My lord, I would, my lord, to cut short the matter, my lord, they would possibly be, my lord, seeking extension of time to file, to extension of the interim order. Now, my lord, the appeal is appearing before the appellate court today. My lord, I would humbly beseech your lordship that kindly take it up, my lord.
No, my lord, I strongly oppose this. It is expiring today. It is on their prayer that it was listed today. Mr. Kormokar appeared when I mentioned the matter for extension of interim order. I prayed that it...
There is one word in English language that is called court etiquette.
Lordship.
Do you know this?
Lordship, I bow down.
Kindly take it up at 3 p.m., my lord. If the appellate court, my lord, does not interfere with...
What happens if the matter is not taken up, my lord?
Tomorrow.
My lord, my interim order is expiring today.
My lord.
Tomorrow or Monday?
My lord, then kindly extend it only till tomorrow.
No, then my appeal becomes infractuous. That is why. Kindly take it up at 3
No,
p.m.
when if there is an interim order,
Yes.
let this be extended for 2 or 3 days.
Yes, that is all. Then my difficulty would be, my lord, I would have to prefer another appeal.
No.
From the order, yes. From the order of extension.
No.
Then, my lord, today I cannot...
When you have preferred an appeal against which order?
The ex parte ad interim order.
There is a contempt also pending.
Is there any stay?
No.
There any stay?
No.
No. The appeal is appearing today.
Right, but there is no stay at present.
No. It is appearing for the first time today.
Okay, for the first time.
Yes. Kindly take it up at 3 p.m. At 3 p.m. I would humbly say.
All right. For the timing, I am keeping it at 3 p.m.
I am obliged.
My lord will kindly take up item number 9 and 10 both at 3 p.m.
Yes.
Much
Item 11.
Item 11, Lord, I appear for the plaintiff. Defendant, I'm sorry. Lord, just
My lord, sole defendant died, my lord. I made an application for setting aside the abatement along with the.
This is J4.
J3 is pending, my lord.
Direction বাকি লিস্টটা দেখিয়ে দাও
My lord, other matter is pending, my lord. 28.
Just a minute, let me understand this thing. GA4 is for
Setting aside the abatement.
no, GA5 is for setting aside the abatement.
GA4.
GA5 বলেন
GA4, yes, GA4 is for delay, condonation of delay, setting aside abatement, substitution.
actually আমাদের application is HON'BLE.
Have you any objection?
Yes, my lord. My lord, it has to be heard with my application being GA3, my lord. This
What is
application, my lord, my application not seeking dismissal of the suit. My lord, the suit has already been abated, my lord, quite some time ago, at least 2.5 years ago. And my lord, after when I filed this application for dismissal of the suit, my lord, they had come up with substitution, my lord.
Where is GA3?
I don't know why is it not appearing, my lord.
28th April.
My lord, it should be tagged along with that, my lord, this application.
As the learned counsel submitted, GA4 of 25 should be heard along with GA3 of
25.
3 of 25, which will appear in the list on 28th April 2025.
Yes, my lord.
Let this suit along with the application appear in the list on the same day.
On the same. Grateful. Extremely grateful, my lord.
Item number 12.
Please, this is my application as an
Who is your other side?
I am for the petitioners, my lord. My lord, I appear for the defendant in the main 88. Matter, my lord, sorry. Matter, my lord, this honorable court, my lord, passed an order on 3rd February 9. Wait, 3rd February 2022, my lord. Pursuant to that order, my lord, we have published the auction notice in the Delhi newspapers, in 3 newspapers, according to the.
Who is the intervener? You are the intervener. Have you got the copy of this application?
Yes.
Any objection?
Yes,
Exchange of affidavit is yet to be done.
And in this, and we've also filed a supplementary affidavit as per the direction of the coordinate bench, might be in your lordship's brief.
That is not here then.
Lordship, the only thing I will take the affidavit. Only thing is, Lordship, we have finally found a buyer. In pursuance of those newspaper publications that were made, a buyer has come. Lordship is aware.
I understand your problem.
So Lordship just considers that and gives a time to file our exchange and affidavit.
The application is considered after filing.
Absolutely, absolutely. Absolutely.
All right.
Lordship, we will do
I am not allowing any sale right now. Let this intervention application be decided first.
Just Lordship, only thing is that Lordship just gives us short dates. We will.
Yes, that for expediting the matter. The learned counsel for the plaintiff petitioner. You are the petitioner.
Yes.
Praise leave to file affidavit in opposition in GA1 of 25. Leave is granted. Full stop affidavit in opposition shall be filed within 2 weeks.
We will do it within a week. 1 week.
All right, within 1 week. Semicolon. Affidavit in reply, if any, within 1 week thereafter. Let the application appear in the list on May 8th.
He is deeply obliged, my lord. 13.
Item number 13.
Partition suit settled between the parties, my lord. I am for respond numbers 57, 58 and 59. Everybody else, my lord, also has settled, I am told.
Terms of settlement.
He is for the plaintiff. My lord, I appear for two of the respondents, my lord.
Terms of settlements are there or not?
Yes, yes.
Annexed application.
Annexed to the application, annexure X. page 39.
Have you checked it thoroughly?
Everybody is a plaintiff. Party.
Where is the original?
Page 39 onwards, my lord.
Where is the original?
Original? Here is the original.
File that. Otherwise, there will be problem in drawing up decree.
Yes. One of the sisters, my lord, has filed this partition suit. We have now settled with her.
Terms of settlement is filed today by the learned counsel. Duly signed by all the parties. Full stop. Let the same be kept in record. Full stop. In terms of clause 41 of the terms of settlement, all litigations, proceedings, proceedings, be it civil, criminal, or otherwise, shall be withdrawn by the parties, withdrawn or dismissed. Full stop. Let the suit be disposed of. Let there be a decree on compromise. No, the decree disposed of the category. Let there be a decree on compromise. The terms of settlement shall be part of the decree. The suit will be disposed of accordingly.
My lord, this is a partition of a Mitakshara family. So, my lord, every person in the family, member of the family acquires an interest at birth. So, my lord, every individual had been, my lord, implemented as a party, as defendants here. To be indicated, my lord, is during the pendency of the suit, my lord, 5 persons have died, but their heirs are already on record. Because, like I said, Mitakshara family, my lord, they were, yes. So, no substitution is required.
Submitted by the learned counsel for the
Plaintiff, my lord.
Plaintiff. Who are they?
I'll tell your lordship, my lord. Defendant number 15.
Just a minute. 50.
15. Defendant number 3131.
50. 15.
15. Yes, my lord. 15. Defendant number 31. Defendant number 41. 41. 42. And 46. These 5 individuals, my lord.
The learned counsel for the plaintiff submitted that during pendency of the suit, defendant number 15, 15, 31, 41, 42, and 46 expired. Full stop. Their legal heirs are already on record. Let decree be drawn up.
My lord, their names can be expunged from the decree to be drawn up, my lord. Only that.
Their names may be expunged from the decree.
Please, my lord, I'm most grateful. Extremely grateful.
Suit may be disposed of along with all pending applications.
Item 14.
My application, my lord. Defend numbers 15 to 20. My demurrer application to the plaint.
Exchange of affidavit is complete?
Yes, my lord.
With filing the reply today.
Filing the reply with a lot of effort. They finally filed the affidavit. We have filed the reply within time. This is the reply. It upore abar ki lagano ache?
Full order to the department.
What are the grounds?
Everything.
What are the grounds of dismissal of suit? Rejection of plaint?
Primarily no
Where
cause
have
of
you
action.
stated this?
Yes.
Which paragraphs?
Yes. Kindly have a look at my 711.
Yes, 711. Which
Yes.
paragraphs?
Yes, Manoj, I'll just look.
59 of Limitation Act. That is one point.
Manoj, paragraph 6, page 19.
31 of Specific Relief Act.
Yes, Manoj. Page 19, paragraph 6 sums it up. Most likely, my lord, if I show your lordship the plaint and the schedule B to the plaint, it should suffice. But I might take a little time just to show the averments also. It's an interesting suit that's been filed.
From 6, in paragraph 6, you have given this point.
Paragraph 6 at page 19 of my demurrer application, the points on which I seek the demurrer are mentioned. If your lordship just looks at the plaint, kindly have a look at the plaint separately. Plaint is not annexed to. Please have a look at the plaint, Manoj.
Give me the case. First, give me the nutshell of the case.
Manoj, this plaintiff comes forward and asserts a title and asks for delivery upon cancellation of at least 4 registered documents, 1 deed of gift of 1948. In the suit, a delivery upon cancellation of an order passed by this court. In this suit, a probate that was granted in a testamentary proceeding to have that order be declared void, and perpetual injunction restraining. He claims his right from X, stating X was the owner, X has sold it to Y on the basis of a will or a probate. So X is defined number 26. Defined number 26 is stated to have gotten the property on the by the dint of a probate in 1990 of one Charubala Devi. This defined number 26, against whom no reliefs are claimed, has sold this property to this plaintiff sometime in 2011. This suit is filed in 2016. If your lordship just looks at the prayers once, so the essential grounds are, my lord, but it makes for a very, very interesting read. Please have a look at page 50 of the plaint. Declaration, first prayer, declaration that the alleged deed of gift dated 1st August 1948 is a false.
That is challenging the deed.
He's challenging
1941 deed.
1948 deed of gift. False, fabricated, manufactured document, and is the result of a fraud perpetrated on Charubala Singh Dev or Charubala Devi. Who is the plaintiff? Plaintiff is Kalimata. So a person who was a party to the document in her lifetime has not assailed that document. Charubala Devi, by dint of a will, their cases had given this to defined number 26. Defined number 26 has, defined number 26 has got it from Aparna Singh. So Aparna Singh gets it from Charubala Devi. Aparna Singh sells it to defined number 26. Defined number 26 sells it to the plaintiff. But the first prayer is for delivery upon cancellation, not in so many words, but it's for a declaration that a document is a fraudulent document by a party who's not a party to the document itself. So Charubala Devi in her lifetime does not assail this deed. This is a registered deed of gift. So in her lifetime, it never gets assailed. Charubala to Aparna, Aparna to D26, D26 to plaintiff. Plaintiff comes and asserts that the deed of 1948 is a product of fraud. And the entire case is on the basis of this deed. It hinges on prayer A. So if his prayer A can't be granted, everything else will fail. Now, what is everything else? Kindly have a look at. Declaration that all documents referred to in the plaint, which are more fully and particularly Schedule B to the plaint, purporting to transfer, title, or create an interest in the suit premises and part thereof on the strength of the alleged deed of gift of 1948 are also false, fabricated, or manufactured. So on the basis of the deed of gift, whatever Charubala Devi has executed, your lordship will have to now, on the strength of a suit that's filed in 2016, ask for all of this to be declared as a product of fraud or its manufacture or fabricated document. Now, what are these documents? This is in Schedule B. If your lordship looks at where Schedule B is.
Of the plaint?
Of the plaint. Kindly have a look at Schedule B. Now, please have a look. This arduous task and this possibly incomprehensible task under law that your lordships have been now called upon to decide. He asked for so he first says that the deed of gift to which he is not a party, which during the lifetime of Charubala Devi does not get assailed. Charubala Devi herself does not assail. In 2016, this 1948 deed is to be declared as a fraudulent deed. And all consequential deeds are to be declared as a product of fraud or are manufactured documents. These are at page 55, Schedule B. Please have a look at this one. This registered deed of gift of 24 July 1975, executed by Marilinda Bernadette and Vikramaditya Prasad Singh Deo and Udayaditya Prasad Singh Deo on either part, registered in so and so. So a registered deed of 24 July 1975. Then a lease deed, serial number 2. This in 2016, your lordship will have to say everything is bad. Lease deed of 11th of September 1984. Disregards the rest of it. Not. Agreement for sale by Bhuvaneshwari Prasad Singh Deo with Bimal Kumar Jhajaria, and consequently the decree in a 1973 suit
Yes.
A decree of, so a decree is also has to be declared as a product of fraud, and the decree apparently is a manufactured document because that's his prayer B. Consequently, the decree passed in 1973 suit, conveyance dated 24th August 1981, executed by learned registrar of the Honorable High Court in favor of Bimal Kumar Jhajaria. So, if your lordship looks at serial number 4, Bimal Kumar Jhajaria is the owner now, because he asked for a delivery upon cancel, not delivery upon cancellation. That's also one of my ground. He asked for this 1981 registered conveyance to be declared in 2016 as a product of fraud. This 81 document is by which one Bimal Kumar Jhajaria becomes the owner of the suit property. This suit property he has purchased in 2011.
In fact, all these documents are to be assailed. The last document belongs to the
It gets better. Somehow, I don't know how the suit was cast and on whose advice, a letter of administration granted by this court has been asked to be declared as a product of fraud by a suit. This itself is barred by law. The moment Indian Succession Act comes in, it's a code by itself. You cannot have a separate suit asking for anything with regard to any order, be it a probate or a letter of administration granted under the Indian Succession Act. And I'll make good this submission with at least 3 Supreme Court judgments. The other part is, my lord, if one person on the principle of nemo dat quod non habet, what I don't have, I can't give. So a person in his or her lifetime, if has not assailed a particular document, then his predecessor in interest or title cannot assail that document. The third point is section 27 of the Limitation Act. If no steps have been taken for recovery of possession of the premises.
So you will stand on the point, so far as limitation is concerned, that you are harping again and again. Even if we assume that this order will come within the ambit of the suit, that was passed in 2013.
What are you looking at?
6. See item number 6 of documents relied upon.
This doesn't have a date. letters of administration obtained by Maheshwari Devi
Where
in
is B?
respect of page 56, serial number 6. Letters of administration obtained by Maheshwari Devi in respect of the estate of Durgaish Kumari Devi in PLA of 1997.
Yes, 56.
And an order of this honorable court of 24th July 1998. This your lordship will find a serial number 7.
So the latest document belongs to the year 1997.
PLA of 1997.
Let us assume this will come within the ambit of the suit.
He made it. In the suit, he asked for all this to be declared as a product of forgery and manufactured. That is his cause of action. Kindly have a look at serial number 7. No,
I got your point.
But I will just take. I'll have to take your lordship to the plaint because the devolution is important. But
In reply, will say that.
I'm sorry.
You say that in reply, he must have some defense against this. I got your point. First thing, clubbing of jurisdictions. Testamentary and ordinary jurisdictions are clubbed. Second thing, limitation. Documents are of either 48 and the latest is of
97. Or 24 July 1998, an order passed by this honorable court granting leave to Maheshwari Devi to sell the move property.
2013.
Serial number 7.
Possibly 2013. Even if we count the order itself.
So that he has asked for 1 to 7.
Even the last order was in 97.
That's right. 1998. Serial number 7 at page 57.
No, 97. Order dated 98. Sorry.
98. Order dated 24 July 98. Granting leave to Maheshwari to sell immovable properties of the estate of Durgesh on 18th.
All right. I got your points. I will hear Mr. Mitra then.
But then I will have to address your lordship on the devolution and take your lordship to the plaint.
Let me hear him. Let me hear what he has to say against this.
I will also take, his defense is going to be what he stated in the plaint, that I have come to know.
Cannot travel beyond that.
Yes, his defense, his cause of action is, I have come to know on
He will explain only why belated documents, earlier documents.
Date of knowledge, he will say the most standard, hackneyed, it's a mixed question of fact and law.
Let me
so
hear
that is something your lordship will hear.
Has argued on my behalf.
Yes, I know this.
No,
so
that should be the argument. That should be the natural argument.
Yes, he's going to come and say it's a mixed question of fact and law. Can't be. So to counter that, I anticipate that. I know Mr. Mitra gives me at least today or some other day to cite a few decisions on 4 different points.
Have you the decisions right now?
No, but I'll give you lordship. I'll have to take your lordship to the point, but I'll give you lordship the point that I wish to address your lordship on. One is there is no cause of action because the property stands transferred before he had purchased the property. And his predecessor in title during her lifetime has not assailed it. So when the predecessor in title during his or her lifetime does not assail a document, then the successor in interest or title cannot assail the same. There's a division bench judgment of our court. I'll cite it that. Second is your lordship has been now in this suit. If your lordship looks at 6 and 7, letter of administration obtained by Maheshwari Devi, it can't be by way of a suit. The law is clear. Indian Succession Act is a code
Revocation
by itself.
only.
You have to go for a revocation. Serial number 7. An order dated 24 July 1998 in PLA granting Maheshwari Devi to sell. So this entire sale that happens has happened before this person has bought it. The sales have happened pursuant to orders passed by this honorable court. These orders in a separate suit, he would have had to probably had a different remedy. I doubt Mr. Mitra was there when this plaint was prepared, but now he has to defend it. But now he has to defend this plaint. But this serial number 7 can't happen. The third is, my lord, when there is a registered document, the purpose of registration of a document under Section 3 of the Transfer of Property Act is to put the world at large on notice. Once a
question of fact. Basically, you are going on 2 issues. One is limitation.
Limitation, yes.
Second is clubbing of jurisdiction.
Yes, my lord.
That these two are points.
No, third is the other very important point, where in the plaint itself he alleges that declare this deed of gift to be a product of forgery or manufactured document or a fabricated document. In this deed, this person is not a party. It's a 1948 deed executed during the lifetime of Charubala. Charubala Devi in her lifetime does not assail this deed. This is separate from the point of limitation law. This is purely on a question of law. A party to a document in her lifetime does not question that the document was established by fraud. The property thereafter, so it is possible in law that, let's say, like in a Mitakshara family, X has, because on birth I get a right, X has gifted the property to Y. X's son on attaining majority comes and questions it. It's permissible. That X did not have the right to give it away by way of a gift. When I become a major, I come and, or when I was a minor, through somebody else, I come and check. But this is a stranger to the document. It's a stranger to the family. Nobody in their lifetime has assailed this document. So a stranger to the document who claims benefit of a transaction which is independent of the deed of gift
a question of
can't
fact.
challenge it. But this is just on law.
This is a mixed question of law and fact.
But I will probably, my endeavor would be just from the pleadings in the plaint to show that this is simplicity an issue of law. Because he alleges, if your lordship looks at prayer A, his first prayer is, I'll just read it for my own understanding, Lord. Kindly have a look at prayer A at page 50. Declaration that
1948 did on the ground of forgery
is a result of fraud perpetrated on Charubala. Well, it is this part which finds its folly and is hid by law. He's not saying it's a fraud perpetrated on me. It's a result of fraud perpetrated on Charubala Singh Deo. Charubala Singh Deo or her predecessors in title in their lifetime or at no point of time has assailed this document. When it is not assailed by Charubala Singh Deo in her lifetime, then a stranger to the document can't come and assail it.
Come on the next with your judgments.
Yes, Lord, I shall do that. Lordship will give me some time, Lord, because I'll have to take your lordship to the pleadings in the plaint. It makes a very interesting
I will do
read.
that, but how long would you take for producing these judgments? 7 days?
Yes,
15
yes,
days?
yes.
After that long holiday of there's a 4 days holiday in month of May.
No, I can come back before that.
Friday, Saturday, Sunday,
9th,
Monday.
that's on 9th to 12th. I can come back before that, no?
I also get ready. Whatever, man.
5th May.
5th May, I'll come.
Hard in part adjourned to 5th May. Hard GA 3 of 24 in part adjourned to 5th May.
The suit will be here, man, now. 2016 suit. Any event it's here in this court.
Tomorrow may not be.
So that if there is one plaint that is a product of clever drafting, it is this. Your lordship would have seen Justice Iyer's judgment followed by Justice Rumapal's judgment 2004. A suit that's based on an illusory cause of action or is a product of clever drafting must be nipped in the bud. This is one of those suits. Grateful.
Item number 15, 16, 18 and 19.
Item 15 is my application under section 340. Item 16 is my learned friend's 340 application. Thereafter, item 17 is GA5, which Mr. Ghosh, Mr. Rupak Ghosh was arguing, and thereafter Mr.
Senior Mr. Devnath Ghosh was arguing. But I am told that Senior Mr. Ghosh will continue his argument in this application.
With regards to GA5, so Mr. Ghosh is in some difficulty, Your Lordship. If that could be kept on any day after the next Wednesday.
Very well.
Next Wednesday is 30th.
So any day after that.
On prayer of the learned counsel for the?
This is for the plaintiff. No.
Plaintiff adjourned to 20th May.
Respondent.
Your Lordship, I am for the plaintiff.
Respondent
yes.
adjourned to 20th May.
Lordship, this is for all the 4 applications?
All the applications.
Very good. Great.
Which one?
Item
7 valid.
Item number 7.
It's for grant of probate of an will, my lord. No objection from no corner, my lord.
What is the status of the application?
Yes, my lord. But the status, my lord, in the last order, my lord, has recorded, my lord, that GO was disposed of in 2023. It was for the appointment of guardian ad litem, and that was my last order. My lord. Kindly see, my lord. And my lord, attesting witness, my lord, was brought, my lord.
For argument?
Yes, my lord, today, my lord, the attesting witness was examined, my lord. But actually, my lord has kept, my lord, that if your lordship has any query or for that purpose, because the attesting witness, my lord, we were favored, my lord, the attesting witness was entirely examined by your lordship. So it cannot be imagined or presumed that we have put by any chance our choicest question and got an answer. Entire deposition he has made before your lordship in response to your lordship's query.
Where is the propounder of the will?
But the she resides in Bangalore, my lord. Bengaluru, my lord, but she has made his all her affidavit, everything is there, my lord.
Why she will not come? It can be over video conference.
Yes, but and if your lordship directs, so she can, my lord. But I believe, my lord, every part, because the last occasion also, my lord has
document.
But kindly see, my lord. Even at yes, last occasion, my lord, after considering everything, the matter was.
Where is the will?
My lord, the will is at page
Is it exhibited?
12, my lord. No, will is at page 19.
ডিপোজিশনটা দেখি। Who is the executor?
But the executor is my lord, Garima Bhatia, my lord. Executrix, my lord.
Wife or daughter? Executrix is wife or daughter?
Granddaughter, my lord. She is neither. Granddaughter. She is the granddaughter, my lord. She has also made her affidavit, my lord, in record of his
এভিডেন্সটা কোথায়? PW1 এর এভিডেন্স কোথায়?
Garima Bhatia.
এইভাবে রাখা কেন? Let her come.
My lord.
Let the propounder of the will come. You can do it by video conference also.
Yes, my lord. But may that leave be given, my lord, video conference? She will.
So you have to file appropriate application.
Everything is done, my lord.
No, there is a rule for video conference, evidence on video conference. Distance video conferencing, distance evidence.
We appreciate if my lord grants the leave, my lord, at least this time can be saved, or nothing else, my lord. It is true. Yes,
Propounder of the will is yet to be examined. Let the application appear in the list for witness action for examination of the propounder of the will.
In May, my lord, anytime.
Liberty is given to the parties to take record evidence over video conference. Over audio video link, on audio video link. Let the matter appear in the list on virtually. May.
But everything is done for the purpose of only this part, my lord.
Make it
no objection from any side.
Bring her into the record. Bring her statement into the record.
As that from the lordship.
Item 17.
Wrongly appearing before the lordship. 2011.
কোথায় order sheet দেখি? You have filed an application here.
Yes, sir.
Yes, it's part-heard matter.
Was appearing before Honorable.
No, it is part-heard matter. Unless I release it, it cannot be transferred. It cannot appear in any other list.
But it has been appearing yesterday in court number 9 in the list.
So how the part-heard matter can appear there?
The date is fixed on next Monday.
Yes, it has been adjourned for this week. How is it possible?
I was hearing your application, GA10.
Yes, Lordship.
You showed that judgment of Justice Dattu.
Yes, Lordship.
So I can proceed with this application.
We don't have any issues, Lordship. Lordship will kindly adjourn it today. Lordship will take it up any day next week or maybe on Monday, as my Lordship pleases. We shall mention there that it is a part-heard matter.
Call register original site. Let it be passed over. There we pass over.
Item 20.
I appear for the respondent, my lord. I believe Mr. Ghosh was addressing, but he's
Yes,
not in.
that matter.
Oh, Mr. Ghosh has
That
come
matter.
back. My lord, I
Yes.
was told he's not there.
He stole a march over me in another court when I was online. Now it is my time to steal a march over him.
Well, on the contrary, I got it adjourned because Mr. Ghosh was not there.
I know. But I could not get entry into that. My lord,
GA1 is the review application.
your lordship has
I understand your point.
clarified your lordship's mind with regard to the part-heard issue. May I be very candid as far as the other points of review are concerned? My lord, we are kindly give us some more time. We thought we will sail on this point.
What are the grounds?
But the other grounds are, my lord, that your lordship has not considered.
No, first ground is determination.
Yes.
Where it is stated.
That is stated, my lord. The lordship kindly come.
This is in paragraph 8. Then other points, 7 and 8, basically.
Yes.
Then
Then kindly comes to paragraph 14.
errors apparent on the face of the record.
That had got the registered deeds of gift dated 23rd March 2009 on 20th February 2003. So that possibly cannot be it's a arbitrary. Then kindly come to main grounds are B to
V.
B.
B.
Alphabet B. A B B H. Lordship impression was that since we already had knowledge about the gifts, contempt does not lie, and that limitation will set in. But as far as these things are concerned, I would like to place once more Lordship's decision, which your Lordship has obviously referred to 2001 7 SCC 549, and correlate your Lordship's findings to once more beseech your Lordship to revisit your Lordship's decision after looking at Lordship's decision of 2001 7 SCC 5. All my juniors are vanished today, but may I come back on another day?
Common substance in para 15.
Common substance in para 15.
Errors apparent on the face of the record.
Once a contempt is dismissed, there is no appeal. But if your Lordship holds that there is contempt,
I was about to say that.
500 friends can go on here.
So, heard in part adjourned to 19th May.
Grateful, my lord.
'21.
Take to appear for the defendant, my lord. And consider last occasion, my lord, I have raised an issue, my lord, regarding this suit, my lord, not maintainable. In view of the, my lord, the suit has been filed after the enactment of the Commercial Court Act, my lord. It's for the recovery of area rent.
Any application?
My lord, I have no application. Lordship is directed to file my written notes, my lord. I have filed.
But so far as this point is concerned, it should be hard on affidavit. Because if it is filed after notification of specified value, this is to be returned. So this should be hard on the application, an affidavit.
I'll file an application then, my lord.
Yes, file an application. Liberty is given to the learned counsel for the defendant.
No, my lord, there is a discrepancy regarding the cost title of the plaint, my lord. As because I think they have not amended the cost title. Huh? Department is saying that my lord, still in the name of the UBI.
No, Punjab National Bank. PNB. Yes. 16,321. 16,321.
I'll carry out an application then.
Liberty is given to the learned counsel for the defendant to file appropriate application on maintainability of the suit in this division. Now, to decide on the dispute whether the instance suit should be entertained in ordinary original jurisdiction. No, that's a separate thing. Maintainability on that issue is different. Because this goes to the jurisdictional issue prima facie.
And on that issue, notes on
let this matter appear in the list on. How long would you take?
2 weeks.
15th May. Let the application come. Unless there be an application, how there can be a
22. Item number 22.
Yes. What is GA 1 and 3?
One is for attachment, my lord. Three is for judgment upon execution. The last occasion, my lord, my senior, my lord, had moved the application, my lord, final had given a direction for application. They have given an affidavit of, my lord. I'm only seeking, my lord, 2 weeks and to file my reply.
Mr. Shen, the learned counsel appearing for, you are for? Plaintiff.
One more thing, my lord, may I just indicate, my lord, there is a prior suit by us before the City Civil Court. We have, my lord, affirmed an application under section 10, my lord. It is pending before the learned master for issuance of summons, my lord. Let both of them, my lord.
Right. That is not yet to be, that is yet to be filed.
It has been filed.
Let it filed, it will appear then. Mr. Sen, the learned counsel for the plaintiff. Plaintiff seeks time for filing affidavit in reply. Full stop. Affidavit in reply shall be filed on or before the returnable date. Full stop. Affidavit in opposition filed by the defendant be kept in record. Let the suit appear in the list on 15th May.
Great.
Item number 23 to 25.
Order will be passed in course of the day. Yet to be finalized. Yet to be finished. Yet to be polished. রেজিস্ট্রি অরিজিন সাইট কোথায়?
না হয়ে গেছে।
ওকে বলো আমার চেম্বারে আসতে।
for judgment. Item number 5.
The petitioner, my lord.
Probate refused. Next.
For arguments, item number 26 and 27.
My lord, I am for the plaintiff. My lord, we have concluded our submission. Mr. Shah, my lord, was in submission. My lord, he started on 3rd of April. On the last occasion, time was taken on his ground. My lord, that is the reason today my lord has kept the matter.
Unfortunately, I will have to seek time today because Mr. Shah was to appear virtually, but his flight did not land in time, so he's still traveling. So I would have to seek an adjournment for today.
On prayer of the learned counsel for?
They are the defendant in the first suit, my lord, and the plaintiff in the second petition. Item number 27, they are the plaintiff.
You are for Uma Devi.
No, for Nirmal Kanodia.
Nirmal Kanodia. On prayer of the learned counsel, argument is adjourned to when Mr. Shah will be able to come.
Lordship, any day apart from 27th, 28th, or 7th or 9th of next, 7th and 8th of next month.
My lord, may I pray for my lord this Friday then, my lord? Because my lord, these are my lord
Taken out.
2011,
Huh? Friday means
25th of April, my lord.
25th April. Okay.
Deeply open. Great.
Witness action. Item number 28.
My lord, I appear for the defendant, my lord.
Where is the plaintiff?
But I do not see the plaintiff, my lord. The chief, my lord, was on the verge of being completed. The witness, my lord, is just on his way. He will reach in perhaps another.
Mr. Doshi.
Mr. Doshi, my lord. Mr. Doshi. Oh, he's there, my lord. He's there. He's reached.
He was wearing his coat. But where is your other side?
I don't see anybody, my lord, from the plaintiff's side, my lord. Mr. Lakmani and assisted by Mr. Bhattacharya, Imon Bhattacharya, my lord, were appearing.
I have no other matter. Only I will come back at 3 for another 2 particular matters. You come here. Yes. You are the defendant.
I'm for the plaintiff.
Plaintiff.
Deepak Harshad Rai Doshi.
You are plaintiff or defendant?
I appear for the defendant, my lord.
He is for defendant. DW1.
DW. The plaintiff's witness were, my lord, the witness action was before the
Yes,
commissioner.
yes.
Shown pages 145 to 152 of the judge's brief of documents. Mr. Doshi, what do you have to say about these documents appearing at pages 145 to 152 of the judge's brief of documents?
These are the CCTV photographs, the footages of the incident that took place on the night of the 24th of December. (2019).
63B certificate is there.
My lord, it's being affirmed. It has in fact been affirmed. It will be filed during the course of the day, my lord.
But that has to be identified.
My lord, 65B, my lord, that is an affidavit, my lord, more or less a certificate.
But that might be, it is not in the form of affidavit. Basically, it's a certification. I am doing this certificate, or I am certifying like this.
Yes.
So he has to identify that.
My lord, that certification will be brought forth, my lord, during the course of the cross-examination. That also can be done, because the affirmation part, that is being done. Very. Mr. Doshi, what do you have to say about the present suit, which has been instituted by the plaintiffs, Keshav Bhajanka and Sanjana Bhajanka?
Can you just repeat the question? I didn't understand it.
As in, what is your view regarding the suit which has been filed before this honorable court?
What's your view or what's your opinion?
The opinion is that Mr. Keshav Bhajanka and Sanjana Bhajanka, in the membership committee meeting, admitted to having been involved in the unfortunate incident. That is my opinion.
That will be all, my lord. In fact, my lord, my learned friend, junior friend is correct on that part, my lord. The 65B affirmation, my lord, that will be done during the course of the day. So, my lord, if I need to ask perhaps one more question regarding that.
Couple of more questions.
Couple of more questions, my lord.
Photographs are to be identified.
Identified.
And exhibited.
No, perhaps he's not going to be he won't be the one, my lord, who would be proving those photographs, because of course he's not the person who has taken the printout. But insofar as the electronic mails are concerned, which has been addressed to him, for that a 65B might be necessary. So that is the sole scope, my lord, which would be left. So once the affirmation part is there, I need to put
Tomorrow?
2 more.
Or day after tomorrow?
Mr. Doshi, tomorrow the.
My lord, I'm in some difficulty day after. If your lordship may consider keeping it on Monday, subject to the court's convenience. My lord.
My lord, I'm traveling.
Tomorrow's all right.
Tomorrow.
I'm traveling from Saturday.
To?
Till the 1st of May.
Tomorrow's all right, my lord. Subject to your lordship's convenience.
Tomorrow would you be able to come?
I would request, my lord, if it can be done after the
1st
1st of May.
DW1 is partly examined in chief, further examination, full stop, further examination in chief is deferred to 6th May. Or some more days.
I'm traveling again then. I just wanted to check the day. 6th of May would be.
Lord, if the witnesses are busy, I suggest a commission could be perhaps done if they keep so busy.
Would you pay?
It's in the fitness of things. Lord, they are the ones who are keeping busy. Candidly
May
telling the
would
court,
be Tuesday.
Would you pay for it?
Lord, I have already paid for my own evidence.
That's all.
My lord, 5th of May is better. 5th of May.
5th of May. All right.
5th. Great.
I will come back at 3.
3 p.m. fixed matters, item number 9 and 10.
Item number 9 is my suit. But, there is no interim order in this matter. I seek to file a supplementary affidavit to show how my client is authorized to represent the church. But, may I have the liberty to
But
file
we
a
are-
supplementary? They can file their opposition.
Lord, we are opposing because, Lord, this is the primary point. My case is that he has hijacked an institution and has filed the suit in its name. He is an absolute outsider who's
We are hearing now GA1 of 24 and 1 of 25.
34. So suit number 34, GA1 of
34
25.
is 1 is 20, 1 of 24 is in 34.
Yes. There is no interim order in this matter.
Let me come one by one. GA1 of 24, where is GA1 of 24?
GA1 of 24.
25.
24 ki kore hobe? Suit is filed of 25.
Then it's wrongly written.
Yes, it must be. Lord, suit is filed in 25.
আরে এখানে 1 of 24 This is an application for
To restrain the defendants 1 and 2 who are seeking to represent themselves as I don't know what. As
receiving any money.
the church.
Receiving any money, so and so.
Notorious.
Lord,
I have the canons, I have the trustees.
AO is filed.
No.
this is appearing for the first time. They
But I
perhaps
seek to file a supplementary affidavit to bring this on record as to how I am entitled to represent this Church of India.
In GA1 of 24.
Yes.
25.
CS 30.
This is your application.
Yes, in CS 30.
Okay. Then other?
But that is the second. That is the second. There is an interim order there. There I am being led by Mr. Case.
The interim order is from 20th March 2005. Expiring today. They have filed an appeal at a very related stage. There is also contempt application we have filed. There is a related stage. They have filed an appeal, which is, I believe, listed today. But
it's running in the list.
It is
It's running in.
was not taken up for hearing. So your lordship kept it. I am humbly praying for a limited duration. Please extend the this to be listed on 20. This is the intimation from how it has come up. We don't know. So it was supposed to be listed on 25th April 2025.
Here.
For the division.
Division may.
How it has been lifted, we do not know, but it is there. Today is 23.
So all right. So far as this one is concerned, Mr. Bush, just a minute.
And make it subject to any order.
Lord,
that may be passed
here,
with the
here, Lord,
So far as GA1 of 25 in 34 is concerned, prayer for supplementary affidavit is allowed for the timing. And
Lord,
against
if
this,
my Lord allows, Lord, the prayer for supplementary affidavit, give us leave to file an opposition to the main
Of course.
petition and the supplementary affidavit.
Of course,
Because
definitely.
that direction has to be given because, Lord,
Absolutely.
subject to objection, Lord, we.
leave is granted to Mr. Bhattacharya, as prayed for, to file supplementary affidavit. How long would you take? 7 days?
Lord, I'll file it, Lord,
The
with it.
supplementary affidavit we take it on record. It's safe. I've served the copy.
It is filed.
Serve the
Okay,
copy.
shall I check?
No, no.
I've equally so.
Acha.
Supplementary affidavit is filed today by Mr. Bhattacharya, the plaintiff herein. এটা হচ্ছে CS 34 of 2025, GA number 1 of 25. দেখুন supplementary affidavit filed by Mr. Bhattacharya on behalf of the plaintiff be kept in record. Affidavit in opposition shall be filed within
Period of 2 weeks.
within 2 weeks. Semicolon. Affidavit in reply, if any, within 1 week. Within 2 weeks thereafter. The suit along with the application shall appear in the list on 22nd May.
Lord, may I just make one humble submission? Lord, I want, Lord, the point. I just want the point with regard to acceptance of additional documents by a supplementary evidence kept open, because I want to make some argument on this. Now,
Very
the
good. I am not
CPC is
passing any
amended.
order.
No, I know. But just keep that point open, because your lordship is accepting the supplement.
Kept in record. Be kept in record. This
Yes,
much.
Lord, all points be kept open, including the
I have
point.
not passed any order. I have not expressed any of my opinion.
I
So
know.
be assured.
But Lord, once the court takes a document on record, Lord, later on we can't raise, Lord, the point with regard to maintainability.
It is made clear, comma, as submitted by Mr. Court, the learned senior counsel. The documents filed additionally in course of supplementary affidavit is not herein admitted, or any final order as to admission of those documents are passed herein. The question is remains kept open.
Instead of 22nd, it's just a day before the
After vacation. 10 June, 11 June.
First, 30.
11 June, okay. Now GA 34 is over.
34 is off.
So far as 35 is concerned, when the interim order was passed?
Ex parte.
Ex parte order which was obtained.
We were not heard.
And now, that's why it was verified. Now, if my learned friend wants to have an extension, we can't also have it.
Which is the order?
Well, the 20th March 2025 was now. We have also filed a
Till 23rd April.
Yes. And Miller, in the meantime, as I told you, Lordship,
Let it appear in the list on Monday. Add interim order till Monday.
Everything is this way. This is my submission, of course.
Well, just a minute. Monday and Tuesday. Monday. Let it appear on Monday and interim order till Tuesday.
Lord, the plaintiff is entitled to obtain an ex parte interim order in the event it satisfies the court that there is an urgency. So, Lord, in this case, in view of the order of 20th March, I issue that he has satisfied the court. Obviously, he has. And he has obtained an order of injunction. And it was so urgent that he could not wait for the defendants to be served and heard. That is an impression that should be given to the court. Now, my learned friend has obtained an order of injunction on a development work which is going on from 2014. On the premise that I did not know from 2014 that a 4-story building, 3+6-story building has come up on a plot of land. I did not know. All of a sudden in 2024 I have come. Be that as it. My contention through the extension is that yes, you have been able to satisfy the court, you have obtained an injunction. But you can't have it extended ex parte, because now that I am appearing, I need to be heard. If I am to be heard, because I cannot suffer an injunction extension.
Have you filed AO?
There's no direction. No direction.
Yes, the reason why I filed an appeal at that point of time, the regular appeal court was not there. I mentioned the matter before the other court. The other court said that I am already burdened with criminal matters. Please wait. So we had no other option but to wait. Now, the question is, today my learned friend will have to satisfy only one thing before he seeks an extension. He has claimed declaration and injunction on a construction on a plot of land, which is admittedly outside the territorial jurisdiction of this court. Admitted. There cannot be no. Now, to get an order of injunction on that, he'll have to satisfy the court before he gets an extension that the court has jurisdiction to pass, because it's a question touching the jurisdiction of the court, and will not. It's been well settled and it's now been reiterated that even an injunction application, if you want an interim order of injunction, the court has to first decide on the question of jurisdiction, because that is the cardinal. So, I would request my learned friend that I have indicated in one line that this court does not have territorial jurisdiction. If he wants to address on that,
I'll address in 2 lines.
Let him do, thereafter I'll meet it, and thereafter your lordship will decide whether.
No, Mr. Dotto, look, appeal is pending.
No, but the thing is this, whether the appeal is pending in the sense that appeal has been filed, it has not been taken up for it.
Whatever that might be. When there is an appeal, this court cannot pass any order varying the original order. If we discontinue the injunction order, that's all.
No, but even that extension that your lordship is going to pass, that will not affect the appeal because Lord, the order will stand extended. The point they will take that this order does not survive.
Without anything on merit, without hearing anything on merit, commenting anything on merit. I am not passing since the appeal is pending. An order was passed, reasoned order was passed, whether it is right, wrong, that's separate issue. Appeal court will decide. For the timing, for a couple of days, it may be extended till Monday. That will not prejudice you any longer. Till Tuesday, all right. Very short period.
Point is of the jurisdiction, inherent jurisdiction.
Very good. You have agitated, you are agitating this in the appellate court. Let the appellate court decide. Since appeal is pending, I cannot decide it right now.
Extension of interim order.
I cannot change a decision taken by it. I am now custodian of an order.
That order is a limited order, takes part.
For very short period, 7 days, I am extending it. Coming Tuesday.
Without prejudice, we are, because of this, this injunction was obtained ex parte and we have been running from pillar to fourth because it's an ongoing construction. Even ongoing construction, your lordship knows that all constructions nowadays, Willard, are covered by financial loans from financial institutions and all. Willard, every day I have to incur a financial loss because I am not being able to construct because of this order. It's 30 lakhs, I'm told, Willard, it's 30 lakhs per day.
All right, you go agitate the matter.
Owner of the property, Lord, from 2019, the process is going on. Sanctioning of plan, construction. If he is claiming to be the...
I'm not going into merit of the matter. It may be prejudice someone. Definitely it has prejudiced someone. Either you or Mr. Dotto. Anyway, since appeal is...
I am the owner of the land. I have entered into a development agreement. 6 years down the line, Lord, suddenly one day an ex parte injunction is obtained.
And that the plaint
An appeal is pending as submitted by Mr. Dotto, the learned counsel appearing for the defendant. You are defendant.
Yes. I represent 1 and 2.
Different number 5 and 6. Full stop. Mr. Kaur also submitted that the subsisting injunction order is prejudicial for his client. Full stop. Next para. Both of the learned counsel submitted that the original injunction order dated 20th March 20th March 2025 was passed without jurisdiction.
And ex parte.
Ex parte ad interim order passed on 20th March 2025 was without jurisdiction. Full stop. Without prejudice to the rights and liabilities of the parties, comma, since an appeal is pending, this court extend the ad interim order so granted for a limited period of time till...
May I say this, Willard? The loss is really colossal. Kindly keep it on Friday. I'll mention the matter tomorrow.
25th. All right. 25th April.
I'll mention the matter and I'll
Ad interim order is all right. Come on Friday.
If I can try my luck over there.
I was humbly praying, Willard, let the interim order be.
No, let it be Friday. Let it be Friday because I'm fixing it on Friday. Come on that date.
Much older.
Willard, that is why Willard, we can't.
So it is upon you whether you will pass such a kind of resolution or not.
No, or Pahalgam. Entire Kashmir is one. Willard, kindly, I was humbly praying till Monday.
He is staring at you.
Willard, till Monday, I was humbly praying. Let it appear on Monday. Let it appear on Friday. Let it appear on Friday. Why?
And junior allowed the interim order to be extended.
For 2 or 3 days.
Not allowed.
I forced it. Take it, so I forced it.
The interim order became
Friday. Keep it till Friday.
The interim order became
Friday. No, sorry. I please both of you. Affidavit service in both the applications be kept in record. যে এইটাতে 7 এ কি অর্ডার